Sponsors of United Way, merged with the Mothers of Peace, Toronto Housing, the TD Center, and the city. Thank you.
Today I'll be doing the land acknowledgement, so we can just begin right now. We acknowledge the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit.
Mark, I just want to thank you, Mark, for doing a lot of heavy lifting when I was away, bringing everybody on the table. All the speakers went smooth, and I just want to thank you for that. For ours, and also Ines, promoting when I was away and making sure that everybody attend. And Atta, the young person who is always inspire me. Thank you everyone for making the event to happen tonight. And our first speaker is Caryma. And I just want to say thank you, Caryma, for joining us. Caryma is practical lawyer and executive director for Normal Canada. A topic is a legal search and seizure. Thank you. Taking on Caryma.
Okay, here we go. So thank you everyone for joining. I'm going to kick us off by talking about a very important charter right, and that's the right to be safe from unreasonable search and seizure. So throughout this presentation, I will go over a couple of scenarios where you might potentially encounter police. I will talk about in your car, at home, and I'll also discuss a little bit about schools, since I think many of you may have children or yourselves be enrolled in institutions. And throughout, I will do my best to pepper some tips about interacting with police. Obviously, and I think the other speakers will touch on this, we're in a particularly fraught time, but some of these issues are not brand new. And there's a distinction between having charter rights and being able to actually exercise and assert those rights. So I'm going to do my best to give you some strategies, although recognizing that your mileage will vary depending on the particular circumstances in which you find yourself. So with that said, let's kick it off. And I'll start with an overview of what Section 8 of the Charter actually is. And the Charter of Rights and Freedoms, of course, is part of our Constitution. So that means that they are really essential rights that are granted to every person. And Section 8 in particular is not just for citizens, for example. There is a broader definition here. And in fact, it even applies to companies. So everyone has the right to be secure against unreasonable search or seizure. And I should say that no rights are absolute. So even when we're talking about these essential fundamental rights, there can be some level of state intrusion that is permitted, and we'll get into those scenarios, but the bottom line is that there's a balance between the state wanting to, for example, maintain law and order. Perhaps there are legitimate goals with respect to law enforcement, and that's balanced against an individual's right and desire to have privacy. And when we talk about searches, what I mean is an inspection that interferes with your reasonable expectation of privacy. Perhaps that's an inspection of you on your person, maybe your vehicle, maybe inside your home, maybe your knapsack, any kind of investigation. And a seizure is where something is taken by a public authority without your consent. And so again, the purpose of Section 8 is to prevent unjustified searches by the state, ideally before they happen. And if they do happen nonetheless, then following kind of a court proceeding, it may be possible to toss out that evidence that was collected improperly if the correct steps weren't followed. And the objective of Section 8 is to protect values of dignity, integrity, and autonomy. So you'll hear the word reasonable several times throughout this presentation. And it's a word that's open to interpretation. With our legal system in Canada, much of that interpretation happens at the court level, and judges make decisions and rulings. They identify factors that may be important, to consider in future situations or scenarios. And as far as our structure, the structure of our legal system here, at the trial level, that's where parties are presenting evidence. There's going to be a verdict of guilty, not guilty, and those decisions can be appealed to appeal courts and ultimately to the Supreme Court of Canada. So to the extent that I refer to any decisions here, I will clarify whether those are lower court decisions, which are still important and have obviously an impact on the people who are parties to that case. But the Supreme Court decisions are super important because a lower court has to follow what the Supreme Court says, in contrast to the Supreme Court, who's able to overturn not just lower courts, but even its own decisions. Okay, and sort of the million-dollar question is, how do you know if your rights have been violated? A search or seizure violates Section 8 of the Charter if it interferes with your reasonable expectation of privacy. In defining this term reasonableness, there are some key factors to consider. Firstly, was the search authorized by law? So for example, if police had to obtain a warrant, in order to get that warrant, there is not just some paperwork that needs to be filled out, but there's a burden that police are supposed to meet, and they're supposed to persuade or convince a judge or justice of the peace that this is a search that is not baseless, it's founded in something. That law itself is reasonable. So again, a JP just rubber stamping a search if they haven't really inquired whether that warrant there's a good enough reason for it, that's a potential point of attack. And the manner in which the search was carried out is reasonable. So you can imagine there's a difference between an officer strip searching someone in the middle of a Subway restaurant versus taking that person to kind of an enclosed space where they, again, keeping in mind those values of dignity and autonomy, are searched in a more private manner. Okay, so we'll talk a little bit about strategies for police encounters. Practically speaking, if you are dealing with search and seizure, it's most often going to be police who you're interacting with. And I guess one thing to say at the outset is that choices you make during a police encounter can have a massive impact on the outcome. And that's not to say that there is, a perfect way to act in which case you can avoid negative outcomes, but it is about making smart choices to, in an ideal world, end the encounter before anything problematic happens, and in a less than ideal world, not have your own actions impugned or sort of cause issues with your credibility if the matter escalates. And fully acknowledging that police encounters can be not just frustrating, but also scary and stressful. And let me start with discussing some common mistakes that people can make when dealing with police. Or rather, sorry, these are the tips, and then I'll move on to the mistakes. So the first tip or suggestion is to stay calm. Easier said than done, but a grounding technique that works particularly well for me is to sort of do a countdown from 5, corresponding with your senses. So something that you can see, something you can smell, something you can touch, the taste that's in your mouth, something you can hear, and reflecting on something for each of those senses. And if you're impaired in one of those senses, maybe double up on something else. The idea is to get into a state of mind where you're more grounded and able to make better choices. The second point to consider is not to waive your rights. So we'll get into some of the language that you can use. But for example, if you're pulled over, the last thing you want to do is pop your trunk and say, "Officer, I have nothing to hide, feel free to look around." The charter rights that we enjoy and benefit from were hard earned and shouldn't be just sort of flippantly set aside. When you are asserting your rights, do so with confidence, but never tell an officer, "I know my rights," right? You show them you know your rights by actually asserting them. Very important to never touch an officer. And again, I'm sure the other lawyers on the panel may be able to speak to this, but there are charges that can result from either assaulting a peace officer or obstructing them in some way, that even if you weren't doing anything wrong, they become a problem in and of themselves. So just avoid that at all costs. And don't lie to the police. It's one thing to say nothing, and we are entitled to say nothing in Canada. That is the smart course of action. When you are speaking, you do have to be truthful. Officers are allowed to lie to you, so this is not a reciprocal situation. So keep that in mind as well. Okay. Okay, asserting rights, how can we do that if we don't know what they are? Okay, let's address some of those right now. So first and foremost, you have the right to remain silent. And the best way to assert that is by keeping your mouth shut. That's true whether you've been, whether you're at home or walking down the street. When you're in a car, there are certain things that you are actually required to answer just by virtue of the Highway Traffic Act. But overall, you're not required, certainly not to make small talk with officers. And, I would say that small talk often leads or escalates into an investigation. And remember that cops can be very skilled at their job, and their job is to extract information, and often that information is extracted with a view towards laying charges. So be very, very cautious. You also have the right to be secure against unreasonable search and seizure, and sort of the magic words here are that I do not consent to searches, and I cannot let you in without a warrant. So as far as consenting to searches, officers might say, "Hey, do you mind if I poke around?" And if you have nothing to hide, it shouldn't be a problem. That's a trap. And I'll stick with the car example for a moment. So imagine that you have been pulled over. The officer says, I would just like to take a look around your vehicle. Do you mind if I searched your trunk? And you say, "Yeah, no problem, that's fine." But maybe you're an Uber driver, or maybe you know, your kids borrowed the car, or a neighbor borrowed the car, or whatever, and there's something in there that you don't know about. So you've suddenly opened a can of worms for no good reason. So that goes back to my earlier point of not waiving your rights. You also have the right to not be arbitrarily detained. And when asserting this right, the magic words to an officer are you detaining me, or am I free to go? So that's something that you can say in response to the small talk. And it's something that you can pass along to your teenagers to say as well. And again, a lot of this is easier said than done when we're at the comfort of our home, and, you know, discussing this in a panel format, it's a lot different than staring down a uniformed and armed officer. But the logic or rationale behind the question here is you are cornering the officer, and you are asking them to either confirm that you are being detained, or that you don't have to stay and participate in this conversation and you are free to go. If you are being detained, and that's a possibility, either because they are investigating or they have reason to believe that something may be afoot, you have the right to know the reason for being detained. And the way to assert yourself in that scenario is to ask, why am I being detained? And if in fact that is the case, and you are being detained, or worse yet, arrested, you have the right to obtain and instruct counsel. And to assert yourself there, you say, I'm going to remain silent. I would like to speak with a lawyer. And even if you don't have your own lawyer, you'll be put in touch with duty counsel. Their advice will probably be, say nothing. Okay, so I'm just going to give a couple of quick examples, you know, some practical considerations here. So on the street, if you are stopped by an officer, you may want to consider providing your name and address to be cooperative. And we'll talk, I think, about carding, and so I would defer to whatever advice you receive in that regard, but that may be an avenue where you can concede to answering those basic questions and then launch into, are you detaining me, or am I free to go? And that's point 2, ask if you can leave to end the encounter. If you are in a vehicle, a couple of suggestions: pull over as soon as those lights go off, turn your car off, turn on your interior light, then put your hands on the steering wheel, and rather than preemptively trying to pull out your insurance or whatever, your license or whatever other documents, keep your hands on the steering wheel. They're going to be visible because of your interior light, and you will only produce those documents upon request. If you're asked to step out of the car, you should do so. And if you're asked to do a roadside test, you should do that as well. Okay, when you're at home, you know, you don't want to invite the police in. It's sort of like vampires. They can come in if you let them. So unless they have a warrant, you know, you either want to step outside to speak with them. Maybe if you have a chain lock, you can use that as a barrier, but you don't let them in, because as soon as they're in, if they get a whiff of something and, you know, this leads me to believe that there might be a crime, or they see something that can sort of give them a hook or their foot in the door, so to speak, to do a search. And if they do have a search warrant, you know, make sure it's correct. Check the address, check the date, check the time, check to make sure it's signed. If there's any problems with that, you should be asking to call counsel before you comply with the request. But I will caveat that police can enter your home without permission in urgent situations. I think I'm just about done my time here, so I'll say a few quick words about schools. In schools, students do have a diminished expectation of privacy. So what that means is, you know, their rights aren't tossed out the window entirely, but it's not the same as being sort of in a public space or in your home. So warrants are not essential in the school setting, but the authority must have some reasonable grounds to believe, A, that there's been a breach of the rules, and B, that a search would reveal evidence. There's a distinction between, again, being searched on your person versus your locker being searched, especially if the agenda, for example, clarifies that lockers are school property and therefore subject to searches. And yeah, you know, so that's something to warn your students about, that it's not an absolute right. So with that, I will wrap up my portion, and I look forward to answering any questions during the Q&A. Thank you for your attention.
Thank you for that. A lot of things that I need to remember that what you said, and I'm trying to say, is this the one that people were asking me? And the good thing that we have a video record of it, and I will watch it again. Trying to remember everything. And our next speaker, I'm just pulling, sorry guys. Yes, our next speaker is Raj, Executive Director and Chief Legal Counselor with the Ontario Human Rights Commission. So I wanna say thank you for coming. And Raj, you were the first one, I think, on coming to join. And I wanna looking forward to hear the Human Rights Commission, the new report. Please take it on.
Hey, thank you, Saraya. And thanks for inviting me to this evening's Know Your Legal Rights session and to be part of this amazing panel. I am going to take a little bit of a different approach than Caryma and some of the other panelists, because I'm primarily going to be spending the time that I have talking to you about a report. I'm going to share details with you about a disparate impact, which is the OHRC's second interim inquiry report from its ongoing inquiry into racial profiling and racial discrimination of Black persons by the Toronto Police Service. Now, it's important for you to be aware of a disparate impact because it's the type of report that the Supreme Court of Canada has said that courts can take judicial notice of to put evidence into context and to explain how racialized people may experience interactions with police differently. A disparate impact is also a report that demonstrates that Black communities are subjected to a disproportionate burden of law enforcement in a way that's consistent with systemic and anti-Black racism. Now, some of you may be thinking, I don't need another report to tell me that. But what's significant about a disparate impact is that we now have the quantitative and qualitative data to prove what Black communities have been telling us for decades. Finally, it's important for you to be aware of a disparate impact because it informs the need for policing and police oversight reform. And many of you have probably been following a lot of the discussions that we've been having throughout the summer and into the fall about police reform. And so I think this report does provide a lot of important information, not only about kind of the systemic and anti-Black racism concerns that we have, but also some of the areas that we need to look at when we're thinking about how to address these concerns going forward. When we began the OHRC's inquiry in 2017, our goal was, and it still is, to build trust between the Toronto Police and Black communities. We recognized then, as we recognize now, that the trust was broken. The second goal was that we wanted to use the inquiry to not only get qualitative evidence, which we had ample supply of, but we also wanted quantitative evidence. And we wanted to put those things together to empirically study the issues, to pinpoint the problem areas, and to make strong recommendations to address the roots of the problems. We retained renowned criminologist, Dr. Scott Wortley, to assist with the inquiry, and his expert analysis has been an important component of our work. Some of you know that in December 2018, the Ontario Human Rights Commission released a collective impact, which was our first interim report. This report included the results of consultations with over 140 members of Black communities across Toronto. It included a case law review, which identified a number of cases where there had been findings of racial discrimination or profiling by the Toronto Police. And it included results of Dr. Wortley's analysis of one complete data set, which was the Special Investigations Unit data on police use of force from 2013 to 2017. And the early results were very troubling. For example, Dr. Wortley found that between 2013 and 2017, a Black person was nearly 20 times more likely than a white person to be involved in a fatal shooting by the Toronto Police Service. A collective impact was recognized by the Supreme Court of Canada, which has cited the Ontario Human Rights Commission as an authority on racial profiling and racial discrimination in the May 2019 decision in R versus Lee. That case involved the Toronto Police entering the backyard of a Toronto housing cooperative townhouse to question 4 Black men and 1 Asian man without a warrant, without consent, without a warning. The court held that the accused in that case, Mr. Lee, had been arbitrarily detained contrary to the charter. The court considered whether a reasonable person in the particular situation of the accused would have considered themselves to be detained. And to understand the social context, the experience of a racialized person being questioned, being surrounded and questioned by the Toronto Police in their own backyard in 2012, the court highlighted the results of a collective impact, recognizing that the findings were highly credible and authoritative, and recognizing the role that these kinds of reports play in identifying and explaining the social reality of discrimination and its effects. Now, despite the Supreme Court's recognition and the fact that a collective impact described the accounts of over 140 Black people and identified numerous cases which validated Black communities' lived experiences, there were still critics who refused to accept its findings. They questioned Dr. Wortley's analysis of the SIU data and asked whether it really pointed to racial profiling or racial discrimination. They questioned why the background behind a police interaction was not considered, why the location of where the incident took place was not considered, why criminal history was not considered. They questioned whether there were other theories for the disproportionalities, such as higher rates of offending due to poverty and broader systemic discrimination. The OHRC's second interim report, A Disparate Impact, which is the report I want to focus on today, answered their questions. A Disparate Impact included 2 new studies by Dr. Wortley and his team and presented more disturbing results. The first study, Racial Disparities in Arrests and Charges, examined racial disparities in charges and arrests between 2013 and 2017. It focused on 9 specific offenses that involved police discretion and examined how race can affect charge, arrest, and post-arrest decisions. Dr. Wortley found that Black people were grossly overrepresented in discretionary lower level charges. For example, although they represented only 8.8% of Toronto's population, Black people represented almost 1/3 of all the charges in the charge data set that we looked at. By contrast, white people and people from other racialized groups were underrepresented. Black people represented more than 1/3 of people involved in single charge out of sight driving charges. Now, these are charges like driving without a valid insurance, which are charges that can only be discovered after the police have observed the race of the driver or stopped and questioned the driver. Black people represented almost 4 in 10 of all people involved in cannabis charges during the study period, despite conviction rates and many studies showing that Black people use cannabis at similar rates to white people. And only 1 in 5 of all charges, regardless of race, resulted in conviction. However, charges against Black people were more likely to result in a withdrawal of charges and less likely to result in a conviction than those involving white people. Given the disproportionate rates of charging, you know, the Black people are so grossly overrepresented in relation to these charges, and the impacts that those charges have on people, these low conviction rates raise systemic concerns about charging practices. Now, the second study, which was called the use of force by Toronto Police Service, is a deeper dive into that 2013 to 2017 Special Investigations Unit data that we first analyzed in a collective impact. And it also included a further analysis of lower level use of force. Now, lower level use of force is force that may not reach the threshold of serious injury, death, or allegations of sexual assault. These are all things that would be required to engage the Special Investigation Unit's mandate, but they may still result in serious physical and emotional impacts. The way I usually explain it is, you know, when you're talking about broken bones, that clearly will engage the SIU's mandate. But bruises or bumps may not engage the SIU's mandate. But obviously, those kind of injuries also create serious physical and emotional impacts. Black people were significantly overrepresented in SIU use of force cases and grossly overrepresented in lower level use of force cases. And Dr. Wortley and his team looked at that overrepresentation and looked at whether it could be explained by factors such as patrol zones in low crime and high crime neighborhoods, or violent crime rates and or average income. And ultimately, he found that none of those factors could explain the overrepresentation. So even when you controlled for those factors, you still saw the significant degree of overrepresentation. Black people were more likely to be involved in use of force cases that involved proactive policing. So that's, for example, when I say proactive policing, that's when an officer decides to stop and question someone. Then reactive policing, for example, when an officer is responding to a call for assistance. Whereas a significantly larger percentage of more serious and lower level use of force cases involving white people resulted from reactive policing. Now, the findings in the two studies coming out of a disparate impact clearly cannot be ignored. And that's why the commission made 2 calls for action. The first is we called on the Toronto Police Service, the Toronto Police Services Board, and the City of Toronto to formally establish a process with Black communities and organizations and with the OHRC to adopt and implement legally binding remedies that will result in fundamental shifts in the practices and culture of policing and address and eliminate systemic and anti-Black racism in policing. And that's what, you know, we've heard many people call for throughout the summer. Second, we called on the Government of Ontario to establish a legislative and or regulatory framework to directly address systemic and anti-Black racism in policing. Provincial law has to require all police services in Ontario to do things like collect and analyze comprehensive, disaggregated race-based data across the full spectrum of policing activities. Provincial law must require all police services to provide for transparent and effective accountability processes to ensure that when officers are engaging in racial profiling and discrimination, that they're effectively dealt with. And that is a current gap in the law that we have to deal with. So you may be wondering, how did the police respond after we released a disparate impact? We had called for police to use a consultative and transparent process for working with Black communities and with the OHRC to establish legally binding remedies to address and eliminate systemic racism in the Toronto Police Service. The Toronto Police Services Board responded by releasing their police reform report with 81 recommendations 1 day after we released our report, and then gave only 5 days for the community and for us to review it and to provide our input on it. The OHRC had concerns with these short timelines because they made it difficult for the OHRC and for communities that are most affected by systemic racism in policing to provide meaningful input into the recommendations that were put before the board for approval. Black communities have been victimized by policing and over-policing for decades, and it's our position that Black communities should be involved at every step of the solution, including prioritizing which recommendations need immediate attention through formally binding mechanisms and measurable benchmarks. And, you know, the Police Services Board had hosted several town hall meetings, and that was very helpful and a good step. And in that step, you know, Black people and communities were able to share their perspectives based on their lived experiences, but that's not a substitute for focused consultation on the merits. You know, and when you have 81 recommendations and you want to hear from community about whether those recommendations are taking you in the right direction. And, you know, the report included a number of general recommendations that, again, sound positive, but many of those recommendations failed to commit the board to specific details and concrete action that, in our view, are necessary to achieve true institutional change. In an oral deputation that our Chief Commissioner, Ina Chadha, gave at that police board meeting, which was on August 18th, she called out the board for releasing the report with no notice to the OHRC and minimal time for communities to respond to the report. The OHRC also made an extensive written deputation, which is fully available on our website for those of you who are interested, but I will just sort of summarize some of the key points here. You know, beyond the flaws in the consultation, which I've already spoken about, you know, there are other important gaps in the recommendations. You know, some of these gaps include the fact that there are no improvements in investigating and addressing officer misconduct, and there are no policy directives to restrict the use of force or the laying of charges. We had called on the police to establish legally binding remedies, but there were none in this new report, which means that ultimately we can't hold the police accountable if there's no follow through on the recommendations, which unfortunately is what we've seen with many previous reports. And, you know, as many of you can attest, when we're talking about anti-Black racism or systemic racism more generally, you know, those issues have been studied and documented ad nauseum without meaningful change. And part of that is due to the perpetual absence of legally binding accountability measures. You know, sadly, despite many of the decisions that we've looked at from courts and from the Human Rights Tribunal of Ontario, you know, we have yet to see substantive changes. In our inquiry, you know, based on the information that we've gathered so far, what we've really seen is a lack of effective monitoring and accountability for anti-Black racism, racial profiling, and racial discrimination of Black people. For example, it's unclear whether or how the service and the board have addressed previous findings of the courts and the Human Rights Tribunal of Ontario. When those courts and tribunals found that Black people were racially profiled or racially discriminated against. In our deputation, we listed 8 cases where the tribunal or courts found that racial profiling or discrimination of Black people had happened, yet based on all the information we have, it does not appear that there were any consequences or accountability for these findings. None of these decisions resulted in an officer being brought before the Toronto Police Service Disciplinary Tribunal. Internal complaints were either not filed against the officers, dismissed after investigation, or deemed to not be of a serious nature and resolved informally by the Toronto Police Service, all of which represent a failure to hold officers accountable for anti-Black racism. In one of these cases, there's a case called El Mardi versus Toronto Police Services Board. The divisional court concluded that a Black man was the victim of racial discrimination when he was on his way back from prayers. He was stopped by Toronto police officers, punched twice in the face, searched, handcuffed, and left injured out in the cold. The police officers were also found to have lied when the trial judge questioned him about their behavior. However, based on the information we've amassed in our inquiry, it appears that there were no serious disciplinary consequences. There were no notices of hearing. There was no Toronto Police Service disciplinary tribunal decision about these officers' conduct. Even though cases like El Mardi continue to happen, the board has not established guidelines on how internal complaints in these circumstances should be effectively triggered and administered. And without these important protocols, meaningful reform and remedies continue to be denied to Black communities, which results in little faith in the service or the board's ability to address misconduct and racial bias. So, for too long, there's been this absence of meaningful accountability for officers who strike, ground, and shoot Black people. And that void has sparked hurt, outrage, and protests in Toronto and across the United States. And, all of you here know that the protests that we're seeing across North America are as much about the absence of accountability as they are about the use of force. Without accountability, there is no chance of building towards equitable policing. And that's why we've called on the board and the service to take these strong steps to make sure that officers whose conduct is consistent with racial profiling face investigations and discipline. And we've called on the board to set up things like an early intervention system that captures and tracks bias and racial profiling. An effective system that uses race-based data on stops, searches, charges, arrests, use of force incidents to alert supervisory officers when service members have disproportionately policed a racial group can be really effective it can be used to measure the outcomes at the unit or the divisional level, and it can be used to prevent things from happening if they're implemented correctly. For example, media reports have revealed that the officer who killed George Floyd had a history of complaints, and that the Minneapolis Police Department failed to implement an early warning system in accordance with previous recommendations that had been made by the Department of Justice in the US. A properly functioning early intervention system may have prevented that tragedy. And these are just a few of the problems and possible solutions that we've outlined in our deputation. We're going to delve into legally binding solutions more deeply as we work on our final inquiry report, which we plan to release next spring. I know I'm running out of time, so I'm just going to say in closing, the bottom line is that there is no place in policing in Toronto or anywhere else in Ontario, for that matter, for racial profiling, racial discrimination, or other human rights abuses. All our communities, including the Regent Park community, deserve better. Thank you.
Thank you, Raj, for that. And I get a different kind of energy by listening to you. So there is a lot of things we have to do in order to move on and accountability in the police systems. Just brought a lot of flashback of what is happening, demonstrations that I've been going, all of that. And there is a long way to go in terms of making the police accountable. Thank you for that. Our next speaker is Selwyn Pieters, who is my favorite neighbor, criminal, civil rights, human rights, and also he's vice president of the Center for the Center for Community Learning and Development. So the topic is carding, and I just want to say welcome and thank you, Selwyn. And now I know why you recommend Raj all of the speakers. Thank you. It just give me another energy to move on. Thank you.
Good evening. Thank you, everyone. Let me just thank Raj and Caryma for their excellent presentations. and also thank Alfred and Soria and Mark and the other members of the Center for Learning and Development for doing the groundwork to facilitate this, and Inez as well, and the sponsors. So my topic tonight will be litigation of carding, and you've heard the presentations that Caryma provided with respect to illegal search and seizure. You've heard what Mr. Dhir had to say with respect to the work of the Commission in dealing with this persistent and pervasive problem that we're having with Toronto Police. And so I will discuss the litigation stream, actions that persons can take when they're subject to carding, which is a form of racial profiling. So there are two modes of litigation that can be employed. There's human rights litigation, there's civil litigation. There are also disciplinary police charges through the OIPRD, or the Office of Independent Police Director, which Raj just touched on briefly. So that's a third stream, the OIPRD, but the OIPRD doesn't give you an independent remedy. It simply allows an internal investigation or a public investigation into the officer and a determination as to whether Police Services Act charges or Code of Conduct charges should be laid against that officer. I will speak about pleading a case before the Human Rights Tribunal, benefits of the HRTO process, constraints of the HRTO process, examples of HRTO cases. I will also discuss civil litigation, elements of a civil suit, possible causes of actions, benefits of suing civilly, drawback to suing civilly, examples of successful carding and racial profiling cases, and why do most suit fails. Section 1 of the Human Rights Code is very important when we're discussing the issue of carding. And it says every person has a right to equal treatment with respect to services, goods, and facilities without discrimination because of race, ancestry, place of origin, color, ethnic origin. And these are the social grounds in the code that certainly gets implicated when a person complains of racial profiling or carding. It may be one of these grounds, or it may be an intersection of these grounds. The police may target someone because they're Black and they're Jamaican, or they may target someone because they're Somali, you know, and so different grounds of the comes into play, depending on how the police approach the person and for what reason. And so we call it discrimination based on race and intersecting grounds. So there are a few cases that I will briefly survey. There's a case currently at the Human Rights Tribunal of Ontario. It's called SA by Litigation Guardian AA versus Toronto Police Services Board. And there's M as well by his litigation guardian AA. And interestingly enough, both of these cases occurred, well, one of the cases occurred in Regent Park at Dundas and Sackville Street, and the other one occurred in the Toronto Community Housing complex. We also, that's walking while black case, two walking while black cases. There's a drive-in while black cases as well, which is a form of racial profiling or carding. Aiken versus Ottawa Police Services Board. Maynard versus Toronto Police Services Board. We have working while black, Phipps versus Toronto Police Services Board. Noble and Pieters versus P Law Association. Sandu versus the Regional Municipality of Peel Police Services Board. We have cases of shopping while black, Graham versus Enterprise Rent-A-Car Company, Nasaya versus Peel Regional Police Services Board. So these are some of the cases that are important and cases that people can screenshot and take a look at if they're interested in any of these grounds of discrimination. Let's talk about if you're filing a human rights complaint, it has to be filed within 1 year after the event occurred, or if there's a series of events, they have to be connected closely together. So for one, if it's required within a year, the benefits of the HRTO process is it's inexpensive. Public resources are available, and public resources such as the Human Rights Legal Support Center, which can provide legal services to an applicant free of charge. I know there's Fareeda on the conference as well, and she will be following me as a speaker. She will speak to what services the Black Legal Center can also provide to victims of racial profiling. But one of the benefits of the Human Rights Tribunal process is it can provide a semblance of justice to the victims. Some of these cases are high profile, high visibility litigation, and they bring the evidence to life in the public domain. Some of these cases, and I just cited quite a few of them, set legal precedents, and that's important as well. Another important consideration in human rights tribunal cases is legal costs are not awarded to the applicant, nor are there cost consequences. So if the applicant takes on Toronto Police or any of those organizations with deep pockets and loses the case, then they don't have to sell their house or go into bankruptcy or any form of financial distress because the police or some other entities coming after them for costs. The constraints of the human rights process is findings of carding and racial profiling are rare in Ontario. So we can recite the cases where findings have been made because there are not very many of them. I just discussed the limitation period of 1 year. The burden of proof is on the applicant. Direct evidence is rare. I just spoke about this case here, SA versus SA buys litigation guardian AA versus Toronto Police Services Board. And this was a case where Toronto police officers were assigned to Regent Park to identify and investigate gang members. They encountered a group of youths from Regent Park, and they followed those youths throughout the night through various parts of Regent Park. And then they looked for a pretext to stop the youths when 3 of the youths crossed the red light at Dundas and Sackville instead of waiting for the green light. The police detained the youths and they issued provincial offenses tickets. But later on, they completed police occurrence reports that indicated the youths were being investigated for potential criminal activities and gang affiliation. So the pedestrian stop was a pretext for what was really a criminal investigation. So that's a case that is being considered by the Ontario Human Rights Commission in their investigation into carding. And it's also a case that's before the Human Rights Tribunal, so stay tuned. There's the Aiken case where Mr. Aiken was driving an expensive vehicle owned by his mother. He was carded by Ottawa Police Service. He filed a human rights complaint, and the settlement included extensive collection of data on traffic stops by Ottawa Police. Aiken wanted the project to expand to include pedestrian stops, and the tribunal did not make that order, finding insufficient factual support and and citing concerns as to the cost and practical difficulties of such an order. But we're hoping that in the SA case, we can get the Human Rights Tribunal to go further to deal with that. There's a case that bears my name, and it's called Pieters versus P Law Association. And in that case, I, as well as other lawyers, were in a launch, and we were subject to racial profiling by the law librarian, who approached the Black lawyers and Black students and demanded they produce identification to prove that they were lawyers. The tribunal found discrimination, and it was appealed to the Divisional Court and Court of Appeal. The Divisional Court overturned the Human Rights Tribunal decision, but the Court of Appeal upheld the tribunal decision. But there was one quote that the Court of Appeal made that you must know, because it's important to anyone who deals with carding or racial profiling cases. And this is what Justice Jurians wrote for a 3-member panel. He said, the question of whether a prohibited ground is a factor in the adverse treatment is a difficult one for the applicant. Respondents are uniquely positioned to know why they refuse an application for a job or ask a person to provide identification. In race cases especially, the outcome depends on the respondent's state of mind, which cannot be directly observed and must always be inferred from circumstantial evidence. The respondent's evidence is often essential to accurately determine what happened and what the reasons for a decision or action taken were. So that's an important point to note in terms of litigating racial profiling cases. Pieters is now a leading case in the human rights jurisprudence. We just had a case where the tribunal determined that a customer was racially profiled by a car rental agency. Ms. Graham booked a car rental online. It only called for her to produce her driver's license and credit card. When she showed up to pick her vehicle up, more identification were asked of her. She did not produce further identification, and the car rental refused to rent her the vehicle. And the issue in that case was whether her race, place of origin, or disability were factors in the respondent's treatment of her, namely to require additional photo ID and to refuse to rent her a car. The tribunal found that the applicant's race and color were factors in the CSR's requirement that she provided additional photo ID, because there was not a blanket requirement for additional photo ID at the location based on all the evidence. The applicant was awarded $2,500 as monetary compensation. There are other HRTO cases, Abbott versus Toronto Police Services Board with a delivery driver. And there's a Maynard case. I'm running out of time, so let me just skip through this. The Human Rights Tribunal can be a powerful forum for justice in carding and racial profiling cases. It is inexpensive. The process can, however, be time-consuming. It is difficult to prove carding and racial profiling cases, as direct evidence is rare. Proof is usually by circumstantial evidence. However, once liability is established, there are a wide range of remedies, monetary and non-monetary, that could be awarded by the Human Rights Tribunal. And you must know that in some of these cases that have systemic implications, the Ontario Human Rights Tribunal, which Rad heads as its general counsel and chief legal officer, they usually intervene in those cases. Civil litigation, generally, if you feel that your rights were violated and you should file a lawsuit, you may want to consider consulting with a lawyer. If you go through the Law Society lawyer referral service. You can get a free half-an-hour consultation. You can also even look at Black or the Human Rights Legal Support Center or any other places, community clinics, and they can refer you to appropriate community lawyers. Generally in civil actions, an issue is standing, who is suing, what the cause of action is, whether it's negligence or assault and battery or breach of fiduciary duty or any number of issues. If you sue and liability is established, the issue is damages, monetary compensation for losses. There's also proximate causation. What possible cause of action exists? There's breach of the charter, false arrest or imprisonment, breach of fiduciary duty, which I just dealt with. The benefits of suing, opportunity to recover damages to dignity. You can also, there's special damages as well, general damages. The case can reach a settlement. Most civil litigation cases, like human rights cases, are settled before they even get heard. So the case can result in a settlement. Monetary figures, though, are unknown due to confidentiality agreements. The drawback to civil litigation is expensive, it's time consuming, and it's uncertain. And you may be responsible for costs if you lose the case. So you may have to not only pay your lawyer, but you may also have to pay part of the cost of the other side if you lose the case. So that's a major drawback, and that's something that we usually have to tell the client in our professional capacity, that there are cost consequences if you lose, and we have to put that in writing because the client may forget that we told them that. Findings of liability against the police in Ontario in civil actions for racial profiling are rare, and Raj just discussed the El Mardi versus Toronto Police Services Board case. So I'm going to skip that case. There's also, there was a case called Pert versus Peel Regional Police Services Board. And this is what the Court of Appeal said in that case about carding or racial profiling. Racial profiling is wrong. It is wrong regardless of whether the police conduct whether it's a police conduct that racial profiling precipitates could be justified apart from resort to negative stereotyping based on race. For example, a police officer who sees a speeding vehicle and decides to pull the vehicle over in part because of the driver's color is engaged in racial profiling, even though the speed of the vehicle could have justified the officer's actions. So if the race of the person is implicated in the action of the police, then racial profiling could be established. Some reasons why an action may fail is because of delay. There are limitation periods of 2 years to sue, and some people sit on their rights for too long. And so the action fails because of delay. Delay in either filing the lawsuit, which is missing a limitation period, or delay after filing the lawsuit, so the action doesn't proceed with the alacrity that it should. Sometimes there's a failure to establish a cause of action. Sometimes there's a failure to establish a wrongful act or causation. Recovery of damages in racial profiling cases through civil litigation is possible, but very rare. Civil litigation is versatile, offering a variety of causes of action to a number of possible plaintiffs. Plaintiffs may find it in their interest to settle rather than litigating the matter through a trial. Timeliness is key, and I want to thank you all for your attention, and I hand it back over to Fareeda.
Thank you, Selwyn, for that, and so many insights and so many details to remember. And I know now why the carding still exists and the systematic issues that we have throughout the neighborhood. Oh, wow. Okay. Our next speaker is Fareeda, staff lawyer of Black Legal Action Center, is anti-Black racism and policing. Fareeda, please taking on. I just want to also acknowledge Alfred, Executive Director. It's here, and excited that he joins us as well, and very much supportive of what we do in Regent Park. Thank you.
Okay, perfect. Okay, so thank you for having me. I'm going to be speaking about anti-Black racism and policing. We're going to get into some conversation about language and terminology, and as Selwyn pointed out, I'm going to talk to you a little bit about what we do at Black and how we can assist. So just to give you an overview of what we're going to be discussing. We're going to be talking about the language that we use when we speak about anti-Black racism and policing. And we're also going to hopefully have a conversation about alternatives to policing. And I'm really interested to hear in the discussion your thoughts on that piece. Okay. So I'm a staff lawyer at the Black Legal Action Center. The Black Legal Action Center is a community legal clinic that opened its doors in March of 2019, so we're fairly new. Our mandate is to combat individual and systemic anti-Black racism. So we do that in policing, housing, education law, human rights, employment, social assistance. And I put our vision there so that you folks can see where Black is coming from and the approach that we use to do our work. So our vision is a society where anti-Black racism is named, it's meaningfully addressed, and where the humanity and dignity of Black people are centered, where the laws and legal systems are reflective of the real experiences of Black people, and where racial equity and full participation of all Black people in society is achieved. So that's a pretty big vision and big goal, but I think it's important to talk about our vision when we do our work and we assist clients. So just by way of a bit of background, these are some stats that we can use when we're speaking about the Black population in Ontario. What we know is that a large amount of those folks live in Toronto. We know that 25% of the Black population in Ontario is age 14 or under versus 16% of the population. So that means that we have a youthful group of Black Ontarians. And we also know that 53% of Black Ontarians were born outside of the country. So let those comments frame my comments later in terms of when we talk about policing, the types of things that we need to include and consider at all times. So I wanted to start by talking about anti-Black racism. It's been used, it's a term that's used by a lot of folks. And the term actually comes from Dr. Akua Benjamin. So anti-Black racism is defined as policies, practices rooted in Canadian institutions such as education, healthcare, and justice that mirror or reinforce beliefs, attitudes, prejudice, stereotyping towards people of African descent. So this is the working definition that we use, and we certainly credit Dr. Akua Benjamin, a professor at Ryerson School of Social Work. We attribute that term to her and make sure that we do that every time we speak about anti-Black racism. You know, I think it's important when we talk about anti-Black racism to also talk about white supremacy. And white supremacy is really important because it's the system in which anti-Black racism thrives. White supremacy essentially is this belief of this superiority of whiteness. And that doesn't just mean white people, but that means institutions created by white people. And in this part of the world, that means our legal systems. And so when we talk about white supremacy and how it operates, we have to think about the political, economic, and cultural systems in which we live, in which white supremacy or white superiority has been normalized to the point where it becomes almost invisible. So I thought this was a really important quote when we talk about white supremacy. While the system of white supremacy has shaped Western political thought for hundreds of years, it's never named or identified as a system at all. In this way, white supremacy is rendered invisible while other political systems are identified in studies. And this is key. Much of its power is drawn from its invisibility. And we can think about white supremacy in all sorts of different contexts, even in contexts when we're talking about Black hair, for example, right? We hear, oh, your hair is so different. Well, why is your hair different? Your hair is your hair, and a person who is white has their hair. It's different because that white person is talking about their hair from a standpoint of normalcy. I have, as a white person, normal hair, and you have different hair. So the person of color or the Black person is always othered when we talk about white supremacy. And so I want you folks to keep that in mind when we're talking about anti-Black racism and policing, and that this system that we're operating under really is invisible a lot of the times in terms of its normalization of anti-Black racism. I wanted to also just mention, at Black, what we do is we emphasize the importance of naming anti-Black racism. There's a tendency and a temptation, I think, sometimes to lump non-white folks into one category. And so, at Black, we want to say, because privilege and power is not equitably distributed amongst communities of color, Black people experience racism in a different way. And that's why it's important to talk about anti-Black racism specifically and not racism, because oftentimes Black people get lost in conversations about racism. So that's why we focus on anti-Black racism. Sometimes, the language right now that's being used, some people use Black, Indigenous, people of color. I've heard that people don't like the term people of color and prefer the term racialized. Ultimately, whatever term you prefer to use, that term cannot be used interchangeably with Black. And I think also that helps in when we acknowledge that people of color can be complicit in oppression of Black people. So an important caveat, if you're seeking assistance from Black and you have encountered this in a situation of anti-Black racism, know that you can call if you're subject to anti-Black racism by another person of color. If another Black person has participated in anti-Black racist structures. So those are things that we assist with. And sometimes we have folks who say, well, it was a Black person who called me this, or it was a Black person who was my boss, or who was my supervisor. So know that people of color can be complicit in the oppression of Black people. And ultimately, addressing anti-Black racism helps all of us. So let's talk about policing. And this quote from Robert Maynard, "Policing Black lives," has always been, is important because, sometimes, even this tendency to talk about policing in relation to police officers. But when we talk about policing, we also have to talk about a system of surveillance on Black people and Black community. So that includes child welfare agencies, that includes officers in schools. And so I hope that this quote from Robert Maynard will ground some of that conversation. So she says, "Policing indeed describes not only cops on their beat, but also the past and present surveillance of Black women by social assistance agents, the over-disciplining and racially targeted expulsion of Black children and youth in schools, and the acute surveillance and detention of Black migrants by border control agencies." And again, that's important too, because we know that 53% of the Black population in Ontario was born elsewhere. So when we have these conversations about policing, we have to make sure that it's all encompassing and that we're not leaving valuable members of our community out of the conversation. And this I thought was really important as well. It's, another quote from Robert Maynard. I'm rereading Policing Black Lives. And I think we can look to this in terms of explaining some of the issues that we're seeing, even if we think about Breonna Taylor, for example, in the United States, and this idea that state violence is rarely prosecuted, especially when it comes to Black and Indigenous people. And that's because not only is as Robert Maynard says, not only is state violence rarely prosecuted as criminal, it is not commonly perceived as violence. And that's very important, because you and I see the humanity in Black people, and we know that violence is violence. But if the state doesn't recognize it as violence, or there are legal caveats to whatever specific act of violence we're talking about, there's really not going to be any accountability. And Raj talked about that. Accountability is key. And ultimately, we can talk, and we will talk about alternatives to policing, but if police officers are not accountable for what they do to us, that is, ultimately the biggest problem. The rest of that quote, because the state is granted the moral and legal authority over those who fall under its jurisdiction. So let's keep those thoughts and those quotes in mind when we engage, as we engage in this conversation. So I'm going to turn a little bit to the legal part of the conversation and talk about the Police Services Act. So the Police Services Act is a law that governs the responsibilities and obligations and rules around policing in Ontario. There was mention of the OIPRD, and the OIPRD, the Office of the Independent Police Review Director, is supposed to be an oversight body where the public can complain about the conduct of police officers. As Selwyn pointed out, the OIPRD is a regulatory body. So you can't go to the OIPRD and necessarily get monetary damages or remedies of that nature. It's really more about whether or not the police officer in question engaged in behavior that was contrary to the Code of Conduct. And the Code of Conduct is part of the regulation under the Police Service Act. So regulation 268/10 says that an officer or chief of police commits misconduct if he or she engages in discreditable conduct, insubordination, neglect of duty, deceit, breach of confidence, corrupt practice, unlawful or unnecessary exercise of authority, which is where the majority of Black cases come from. And the other three, the damage to police clothing, consuming drugs and alcohol, and being a conspiring, abetting, or being an accessory to misconduct, we don't really see that often. But we do see folks who come to Black with assistance with matters that are related to unlawful or unnecessary exercise and authority. And that can include things like overcharging. That can include things like even like in relatively benign engagements with the police that turn into excessive big charges. And again, you know, when we look at for the Ontario Human Rights Commission report on Disparate Impact, right? The Disparate Impact talked about how Black people are subject to overcharges. We're just more likely to be overcharged, and that's what we also see at Black. That Black people are coming to us and saying, I was walking down the street and I was approached by a police officer, and then all of a sudden I was facing all sorts of charges. So the OIPRD process is quite an interesting process, I'll say. It can be difficult to go through because ultimately, oftentimes there is no accountability to be found. In situations where an officer is found to have acted in a way that breaches the Code of Conduct, these are some potential consequences that officer can face. I haven't encountered any personally at Black, but these are theoretically, or not theoretically in legislation, this is what could happen to a police officer. And I think someone previously pointed out, the OIPRD, similar to the Human Rights Tribunal, has time limitations. At the OIPRD, it is 6 months from the date of the occurrence. And so a lot of times what will happen is that we'll have folks who call us and say, I had this terrible encounter with police last year, or I had this terrible encounter with police 5 years ago, and I just, have been able to talk about it because I was so deeply traumatized by it. And so these become difficult hurdles for pursuing an OIPRD complaint because of the time limitations. So if you know, or you've experienced something, or anybody who's experienced something, I think can't be overstated. Time is of the essence. Make sure you reach out to Black. So this is how we see anti-Black racism manifest in policing. And remember, we're talking about policing not just in terms of police officers, but all systems of policing Black bodies. So what we see is, again, a racial profiling, carding, the over-policing of Black people and the under-policing of Black people. So what we see a lot of the time is that often Black folks, especially recently, I think in COVID times, are subject to harassing treatment by neighbors or at grocery stores, and the police are just not willing to lay a charge. And conversely, when a Black person is engaged in any type of interaction with the police, there's often a charge. In the bail system, we don't practice criminal law, but we do give summary legal advice in relation to criminal law. What we see is an over-reliance on sureties and really strict conditions. So you'll have somebody who's before a justice of the peace for bail and first offense, don't have a record, and the Crown is asking for a surety, which is the highest form of release that you are entitled to in this country, really. And so we see that a need for sureties, and that can be difficult for some communities who don't necessarily have sureties or family members or friends who are willing to sign for them, and or who may not want to involve their family in getting out of jail. In sentencing, we see that as well in the criminal law, a lack of recognition of anti-Black racism in sentencing. There's a case that Black is intervening in. It's called R. and Morris. It's relation to a young man, Mr. Morris, who was charged and convicted of a number of firearm offenses. The judge in that case, Justice Nakatsuru, took into consideration Mr. Morris's background. And that included things where Mr. Morris grew up. The fact that Mr. Morris was raised by a single mother, the fact that Mr. Morris didn't live in a neighborhood where other options were available to him. And Justice Nakatsuru talked about the circumscribed choices that were available to Mr. Morris and gave him a sentence that he felt was proportionate to not only what he was convicted of, but ultimately his background. And now the Crown has since appealed that to the Court of Appeal. And we're intervening because we also think that this is the type of case that affects Black people in general, and the importance of talking about anti-Black racism, not only at sentencing, but at all times in the criminal justice system. In prisons, we see bad conditions. We see jobs in prisons not given to Black folks, the jobs that pay the best. We see Black people who have jobs like cleaning up or mopping the floor, and other folks get the jobs in the canteens. And so we see that a lot. In the child welfare system and the education system, what we see is a surveillance of Black children, a lack of recognition of the humanity of Black children, specifically in relation to the child welfare system. In the education system, we see that school to prison pipeline with officers in schools. We see students just being subject to disproportionate discipline that often leads to criminal charges or criminal involvement that can lead a young Black person down a really unfortunate path. We see anti-Black racism manifest in employment, immigration, and housing as well. In the illegal act eviction, actually, we see that quite often. So essentially, if someone is potentially engaged in an illegal act and or any individual in that home, that person can be subject to eviction hearings. And sometimes we see, the grandmother who doesn't know that so-and-so's friend is in the house, and all of a sudden, we have an elderly Black person who's subject to an eviction hearing, which we obviously would be able to assist with and find deeply problematic. Okay, so I am going to, okay, so I'm running out of time. So, so this was just some information that we wanted to talk about. And again, we can think about the disparate impact from the Ontario Human Rights Commission to tell us about what kinds of experiences Black folks have. I don't know if any of you saw this on Twitter, if they gunned me down, that hashtag that was going around. And this is how anti-Black racism manifests, right? Images that are used of Black people that reify and affirm criminality as opposed to Black people having fun, being employed, serving their country, graduating. These are not the images that we use for Black people. We use the other images. We use the criminal, the gang signs. And oftentimes Black folks lose their humanity when they're portrayed in that manner. I'm going to skip over this section because Selwyn talked about the Human Rights Tribunal of Ontario. The Human Rights Tribunal of Ontario is a great place that you can deal with anti-Black racism if you're experiencing anti-Black racism in policing, for the reasons that Selwyn pointed out. There are some difficulties with the Human Rights Tribunal because the onus is on you to establish the discrimination. And so for us, we just want to emphasize the importance of taking notes, taking video, getting the names of any witnesses present so that you're putting your best foot forward when you go to the Human Rights Tribunal. And this is a quote from NASA versus Peel Service Board, this idea that the stereotype of a Black person as criminal is closely related to racial profiling, which is a form of racial discrimination. These are some additional considerations that I wanted people to keep in mind when you're talking about anti-Black racism. And I think it's something that we forget oftentimes, that there is a huge psychological and emotional impact of the incidents of anti-Black racism. Not just legally, but personally. We carry these experiences with them and they can induce psychological and physiological stress and behavioral stress, right? I think a lot of us experience what we call racial battle fatigue. There's always an issue that we have to fight. And so I want folks to sort of think about how to take care of themselves when they're engaging in this kind of process. How we can fight anti-Black racism. I'm out of time, I see, but I wanted to have this conversation hopefully in the chat as we sort of embark together. This idea that has been emerging in the public about defund, disarm, demilitarize, and dismantle. And the question that I want to leave you with, is this really radical? If we're talking about a transformative change in policing in the name of Black life, in the protection of Black life, in affirming the humanity of Black life, is that radical? Are there alternatives to policing that we can rely on or go to or even reimagine and think about? And then the last point I want to make is one of our former board members, Sandy Hudson, talked about this. She talked about policing as an irredeemable institution. Because of its genesis, it's not something that we should be working within, but we should be reimagining policing. And so on that point, I'll leave it to you folks to start off our discussion, hopefully, on this. Thank you.
Thank you so much, Fareeda, for that. And it's very empowering in that you're an institution that exists as well. How do you guys doing the service right now? Is it virtually? If people have a question and stuff, how do they access you?
They just give us a call. Let me get this information. If I go back here, I should have left this. So they can give us a call and we do what we call an intake. An intake is basically just some information gathering about what the occurrence is. One of our intake officers will identify what the issues are, and if it's something appropriate for Black, they will send it to one of the lawyers, and the lawyers will then contact the person within 3 business days, 2 to 3 business days. And we will chat with that person and see if we can assist, what happened, and again, we'll go through some of the details and minutiae of the issue. So that's our contact information. And you can reach out to Black. We have Twitter, Facebook, social media. I will drop our phone number in the chat so that you folks can reach out to us. And there are situations I think that you may not know. Is this anti-Black racism? Is this something I may be out of time? It still may be worthwhile speaking to us so that we can give you some guidance in the future and hopefully help you resolve it or at least point you in the right direction.
Thank you for that. And I think it's time for question and answer.
Yes. So just, sorry, let me just get this going here. Sorry, one sec. There we go. Okay, so just a friendly reminder that all materials will be emailed at the conclusion of today's webinar. The email will also have a link to a very brief survey, so please consider taking the time to fill out the survey, as this will allow us to continue to put on these events for the community. As well, if you look in the public chat, I also pasted a link to that survey. And now we are entering the Q&A portion of today's webinar. So please post your name and question in the public chat, and as well if you would like the opportunity to ask the question directly to the panelists. And for the first question, I'm gonna hand it off to Caryma. So we had attendee by the name of Nea, and they asked the question, how would you insert your rights, for example, going back to your illegal search and seizure presentation? Caryma, I think you're on mute.
Perfect. I'm going to distill this into, I guess, 5 ways to assert yourself based on some of the rights that I talked about. So first, you have the right to remain silent. To assert that right, you just keep your mouth shut. Second, you have the right to be secure against unreasonable search and seizure. To assert that right, you can say, I do not consent to searches, I cannot let you in without a warrant, or you can take the actions that I described, for example, stepping outside of your home to speak with an officer, or using the chain lock. You have the right not to be arbitrarily detained. To assert that right, you can ask, are you detaining me or am I free to go? That forces the officer to either acknowledge there is a detention, which leads to subsequent rights, or if there is no detention, you can end that encounter. Fourth, you have the right to know the reason for being detained if you are in fact being detained. And it's as simple as asking, why am I being detained? And lastly, you have the right to obtain and instruct counsel if you are detained or arrested. And to assert that right, you say, I'm going to remain silent. I would like to speak with a lawyer.
Thank you, Caryma. All right, so next we're going to take a question from Joe K. Joe K, can you turn on your video and your mic?
Yeah, thank you, Mark. Joseph Kaseja. Just a quick question. Last week I was taking part of the research which is undergoing about the defund the police by CL&D, one of the agencies that is working on that research, especially concerning the Toronto Police Department. And the same issue came about how Black people understand their relationship with the police. Most of the Black people, I even ask them when they move out of their houses, what's the first thing they think about? Or when they see a police officer approach them, what is the first thing they think about? That fear and that feeling unsafe is really traumatizing people. But back to my question, Adam, I would like to ask, in your presentation, there's been this incident whereby a police officer is engaged maybe in malpractice or misconduct, or as a Black person, I witnessed something with a police officer around, but when you go to court, they'll always try to believe the side or the story of the police officer, even if they're telling a lie. They'll try to see them as a more of a qualifying evidence, piece of evidence. And I don't know why the system has continued doing that way, whereby many people end up getting incarcerated or arrested or remanded when they couldn't find out the truth. The second one is what we call, what we all hear about immunity given to police officers, especially in any situation. If they make a mistake, they'll always be protected by the department. You have seen the other case where Brianna Taylor, what happened, but still they found a way of playing around to make sure that the officer only are charged for shooting in the next room, but not the person they killed. So what can be done, because it's going to take a long time for communities to begin gaining that trust from the police officers. I know there are some bad apples and there are some people who are professional, but I believe police, they need to find a way of creating that rapport with the communities, try to understand the kind of communities that they're living in, what is causing all these crimes, how best can they understand the different challenges. If we talk about the mental health, police officers are not well trained on mental health. When you talk about the mental health, it's a wide spectrum, or they will teach them to be something small, and a few hours of training and they're out. So I believe there's a lot that can be done, even fixing the systems and policies in the police department, because it's going to take a long time for communities to buy back that trust from the police. Thank you.
I don't know if that was, I mean, that was for me?
Yes,
Oh.
please. Yes,
Okay.
please.
Yeah, I mean, I agree with what you said, you know, and I think, I mean, there's a couple things. I think we can do multiple things at the same time, right? We can try to work with what we have right now, but also talk about reimagining the police. I mean, I think, Raj, you talked about the Ontario Human Rights Commission's report came out, I think, on August 10th, and then the Toronto Police Service Board came out with 81 recommendations in a report the next day. And that was heard before the board 7 days later on August 18th, right? And so even attempts to reform, even attempts to offer suggestions that meaningfully address some of the things that you were talking about, the lack of trust, the fear, the overcharging, the overrepresentation of Black people, was done in a way, in my opinion, that may not have demonstrated good faith. So for us as lawyers, what we try to make sure that when people are doing is you're taking notes of your interaction. If somebody's able to videotape your interaction, that'll help you. If you aren't able to videotape your interaction safely, but you see that there are people who have watched this interaction. After the interaction, if you're able, get those people's information and contact. Because building a case is very, very important. Ultimately, a lot of these systems are hard. It's hard to be successful. It's hard to be successful at the Human Rights Tribunal. It's hard to be successful at the OIPRD, but we try because we push. And even sometimes doing that, the process can be really important for our clients. Attending a mediation and sitting across a police officer who treated them in a way and affirming their humanity to someone, explaining that to someone can be really impactful. So yeah, I mean, I agree with what you're saying, and I think it's, you know, that's why, you know, we're talking about just defunding and dismantling, right? That's why this is so important. You know, today I even talked to, you know, a panel of folks about disarming police. Even can we start there, taking away weapons from police officers, similar to models like in the UK or even in New Zealand. And those are the kinds of things I think we should start looking to.
All right. Thank you very much, Fareeda. Next, I'm going to call Ayana. Please turn on your mic and your video.
Hi. So I had a couple questions. The first one I kind of wanted to ask, I guess, Fareeda, you might be able to answer this one, but how and where do we file a complaint about a police officer who has demonstrated misconduct? Number two, my question would be, you had brought up one point about how police officers can be charged or addressed, and it said discreditable conduct, and I'm not sure what that actually is. And then my third would be kind of to your point of looking at reimagining the police force, because if there are 87 recommendations that they've come up with, and they've kind of ignored the interactions of engaging with their community, where do we go from there? Because it clearly seems like they're not interested in actually recreating a bond with their community going forward. So what would that look like?
Okay, so that's a lot. So I'll start with the first one. So the OIPRD, so you can file a complaint with the OIPRD. You can go on their website. There are forms there that you can file. If you are a Black Ontarian, you can call Black, and Black can assist you with filing a complaint at the OIPRD. It's actually a relatively simple process. It's not too complicated in the sense that you can fill out the form, you fill out the names of the officers, you fill out any details about where it occurred, the date, the time, and all of that. And that's something that Black can assist you with. Your second question was in relation to, sorry, can you repeat that? I want to make sure that I'm getting it right.
My second question was in relation to, I think you had mentioned discreditable conduct.
Oh, discreditable.
I'm not sure what that is.
Okay, yeah, so discreditable conduct can be, essentially it's any conduct that brings the reputation of policing or police officers into disrepute. So that can include things like, you know, police officers on an Instagram video drinking and doing drugs and posting it, or police officers in a group chat talking about how much they hate Black people, for example, hypothetically, I'm not saying that, right? So those are things, discreditable conduct, as I understand it, is more related to policing and how that brings a certain kind of perception to the profession of policing. It's kind of similar to lawyering or other schools of profession where your behavior somehow should not negatively impact the perception of whatever professional school you're part of. So that's kind of what discreditable conduct is. I know that a lot of these terms and a lot of those code of conduct infractions can seem like they're related to the public, and sometimes they are. But I think that one's more related to police conduct and how the public and the perceiving police officers. Your third question was related to, I don't know if I said 87, 81 recommendations at the Toronto Police Service Board. And, you know, so in July, I believe they held 4 sessions of town hall meetings, right, to get the sort of perception of the public, and the public was talking, and Black people specifically, and we were talking about the fear, the anxiety, and that was apparently enough for them to proceed with the recommendations without even allowing, I mean, the Ontario Human Rights Commission a meaningful opportunity to analyze and go through those recommendations to see if they are similar to previous reports and recommendations that were found in reports that may or may not have manifested anything meaningful for the Black community. And I think you're absolutely right. You know, a lot of times there's this sense that there are these reports that come over and over again that suggest similar things, but there's nothing actionable and meaningful. And, you know, when Raj was talking about legally binding mechanisms, I mean, that is extremely important, because ultimately you need to be held accountable for what you do and do not do. I think where we go from here and where we go from there is that we continue to push the conversation about defunding, dismantling, and disarming police to a place where we're no longer speaking about this in a radical sense. You know, I get that a lot, that I'm being radical, and I'm reiterating the comments that I made in the presentation. There is nothing radical about protecting Black life. And so I think that pushing the conversation and demanding accountability, I think that's how we get past this, and I guess deeper into the conversation of defunding and dismantling police.
Thank you.
Thank you.
All right, thank you, Fareeda. So next, I'm gonna call Bajan Lynch. Please turn on your video and your mic.
Oh, the video would be a problem, and I don't think we want to do that. But I'd like to ask.
Either or.
So great information here by all the panelists, and you know, as a Black person, I was certainly pleasantly surprised to see that there was that definition of what racism is. I think that is very important when we have these conversations to level set, and it's tied to Black people. So I really, really appreciated that definition and clarification. I believe absolutely the systems are the issue here, and hence why we have the challenges. Every time I get into my car, I am consciously aware of the color of my skin, even more so now that I cannot renew my plates. Really consciously aware. I have to think twice. Do I really need to get in this car? What am I going to do? Is it important? I just have to have that in my brain. But I believe, yes, the systems need to change. So I'm going to kind of answer my question, and that is that, you know, Regent Park is predominantly a brown community, right? And there is racism, not only white against Black, but also brown against Black and other communities. So I want to ask you, how do you think we can tackle those you know, that type of issue, because that does exist. And at me at the micro level, I'm responsible for myself and my neighbors, and, you know, I can do those kinds of things. But at the macro level, so at that systemic level, I can't probably do what Black is doing, or, you know, what the Human Rights Board is doing. But I certainly, you know, can be an ally for other communities. So I want to ask about, you know, what do you think are some things that we can do to really get around that racism that is not only from white to Black, but also brown to Black? Tough question. Anybody?
Gail, it's Nyan, and I would just echo what you said, and you're right that there is racism between different communities that have been marginalized, including Asian people against Black people. Like, it exists. So I just wanted to echo your point.
I'm not sure that I have an answer to this question, but I guess speaking as a brown-skinned person of South Asian and Arab descent, so I'm very aware that there is anti-Black racism in both of those communities. And one thing that I think about sometimes is sort of in a post 9/11 world, when brown skin became sort of its own, it was targeted maybe in a more forceful way, and I don't know that that has abated in any meaningful way. Kind of drawing on like a community's experience or an individual's experience, and drawing those similarities, because steeped in that anti-Black racism are assumptions and stereotypes and stigma. And I guess my personal view is when you're able to internalize something, process it in a way that you can relate it to your own life. So I guess because your question specifically asked about brown-skinned people, I feel like I'm sort of in a position to share my thoughts there. So there's possibly something that could be fodder for reflection, and, you know, that then hopefully will develop into meaningful support and allyship.
Thank you.
Hello. I also want to speak on this subject matter because it is true that there are discrimination within various groups, and sometimes they are the brown versus Blacks, and I find that to be the most painful because of all of our own collective experiences. I recently had this issue where somebody posted these in one of my Facebook lives, right? That's what somebody posted, and you can see from the name it's a South Asian person. So I was very troubled that the person would have done that. And this was a Facebook live that she posted it on. You can see the same background is here that was in this live. You know, that was very distressing. But we have human rights jurisprudence where Black people have discriminated against Muslims. We have human rights jurisprudence where South Asian persons have discriminated against Black people or other races and ethnicities. So it's not something that is one group predominantly or the other ethnic group. It goes with respect to all ethnic groups. And I should say this, that in places where there's one predominant race, there are discriminations based on religion. So if you're in Pakistan, for example, you know, it mightn't be racial discrimination, but it might be discrimination because you're Sunni or Shia or Ahmadi. If you're in Afghanistan, it might be because you're Hazara or Pashtun or something else. Or if you're in Kenya, it could be because you're Luo or Kikuyu or something else. So I think it goes back to the issue of something we discussed called implicit bias. And so, you know, you can't, some people will discriminate, some people will have biases. We all do. It's how we associate it, how we deal with it. And I know Raj wants to say something about it. So Raj, go.
Well, thank you, Selwyn. I actually, I just find this discussion really, really fascinating. And I agree with the comments of Caryma and yourself. I think from my perspective, just building on what the two of you have said, I agree that I think in terms of qualities that you need to see in allies need to be self-aware of their privileges to be useful as allies. They need to be open to continuous learning about other people's lived experiences. I think just thinking about what Fareeda was sharing with us earlier as well, I think, and I think just generally some of the things that we've touched on, I feel like a big thing that is important with respect to allyship is understanding that when it comes to discrimination or racism, it's not intention that counts. It's the impact or the effect of the harm. And I think that that's a really key component. But, you know, I think, you know, whether you're talking about allies in employment or if you're talking about allies, you know, when you're talking about other sort of social areas like services, I think, you know, I feel like when we talk about, you know, whether you're talking about allies or another term that sometimes is used as accomplices, right? You have to have that kind of courage and that willingness to challenge individual and systemic biases and speak out when necessary, and also seek advice and guidance, you know, when there are situations that you're encountering that are raising concerns. Anyway, I have, like, you know, there's lots of other things that we could say about this, but just those are the thoughts I would offer on that.
All right, I'm gonna open the floor to Ishmael. Please turn on your video and your mic.
Like Gail, I'll just turn the audio.
Okay.
Yeah, I've been on meetings all day, so just relaxing here. My question is, in terms of, it seems like there are momentous occasions in history where certain opportunities open themselves up, and then we sort of fall asleep into these opportunities, or things just hide themselves. I think anti-Black racism is a huge opportunity opening itself up because of the tragedy of police misconduct and the murder of Black people. I think there's a resurgence, at least in the public eye, that this is there's an opening. How best could we take advantage of this opening in terms of not only the city of Toronto, also Canada, of making headways, making some concrete wins? Because as I've seen in this neighborhood, at least in Regent Park, I'm involved in several different projects where the answers are structural, but the problems are faced on the ground level. I'll give you an example, the aquatic. Most of our kids don't know how to swim, and the best of the facilities in the world are opened up right before our windows. And then we have to deal with parks, forestry, and recreation. But in order to get a change in policy, we have to go visit City Hall. So my question is, there's a momentous opportunity right now. What are the steps forward? Is it data? Because I know that there's a project with the police that they're collecting data around incidences of harassment. So I'm just wondering, is there a galvanizing moment for us here, or are we going to be working on small projects that lead nowhere? So I'm not sure if I've asked a question, which is I like the organization, the Black organization. I think this is the first time I'm hearing such a concentrated effort, at least from an organization on this issue.
Yeah, I mean, that I think is the question of the day, right? How do we deal with this issue and this beast called anti-Black racism? And from my perspective, I think it's a multi-pronged solution. I mean, we have three other wonderful folks on the panel who are doing different things, but we're all sort of speaking to the same issues, right? Ensuring that folks are informed of their rights, ensuring that research is done in a way and reports are done in a way that data is collected, and so that we can make submissions as lawyers before various bodies and various courts. And what Selwyn was talking about in terms of the different avenues, right? Whether or not you want to use the Human Rights Tribunal or not. I think from Blacks' perspective in policing in general, we want to see reform. And I think that you're right. We are in a watershed, momentous time. And that's why this defund conversation has gained so much momentum, because we are tired. I think people are tired of the same solutions, the same recommendations, the same bureaucracies that plague a lot of our institutions. And as lawyers, we know of this bureaucracy. We know the steps that we have to take to get one win or one element of a win to ultimately lose. But you try because you believe in the law and you believe in your client. But I think that that's what's happening now with this conversation. I mean, we're literally talking about abolishing the police. I can speak about abolishing the police in a way that folks at least want to listen to. And so I think that really what we should be doing is pushing that conversation forward when we're talking about reforms, holding police boards accountable for what they do when they try to sneak in recommendations without meaningful community consultation. I think those are things that we can do to sort of push this conversation forward.
Yeah, I wouldn't mind just jumping in here as well in response to the question. I think that one of the things that I have said in other speaking engagements, just by way of prefacing what I'm about to say, is to date, there's been no police service in Canada that has undertaken the kind of holistic change that we need to see to truly address these sort of deep, pervasive, systemic, anti-Black racism issues that we see in policing. And, in a way, the last 6 months, it feels like in the last 6 months, it's been, it may as well have been 20 years, right? In terms of the shift that I have observed in the consciousness of people around these issues. And so there's definitely a moment to seize. I talked earlier about a collective impact, which was the OHRC's first interim report. And what's astounding for me to even think about now, given the moment that we're in, is that when we released that report, as I said earlier, that was like 140 Black people telling you their stories, their lived experience. That was, numerous cases that, actually demonstrated that the existence of profiling and racism within policing. And we had SIU data that showed discriminatory police use of force. And what was happening was that prospect was so unbelievable to the mainstream that they were questioning every aspect of it. Well, you haven't looked at these other variables, and you haven't, so what is it about where we were then, at least, and maybe where we still are in some respects, that, allows people to ignore the obvious, like what's in front of them, what Black communities have been telling us for over 3 decades. And so I think I completely agree with Fareeda that, like, there needs to be the space in the moment that we're in to have the conversations that people are having about defunding and disarming and demilitarizing. I also believe that at the same time, there are evidence-based measures that can be adopted by police as part of reform that have proven in other jurisdictions to be effective. And, so some have mentioned, people in crisis and having mental health support workers being part of the first responders. And that has been adopted in other jurisdictions and has been extremely effective. Data collection, we've seen all kinds of successes around that. Well, you know, how many police services in Ontario, let alone the rest of the country, collect race-based data? You know, it may surprise you, you know, if you're not like working in this area, that, you know, aside from really Toronto, which just established its policy in September 2019, you know, there's been projects. We've seen the Ottawa project and the data collection that's flowed from that. We've seen Kingston a long time ago, but these have been, you know, very discrete projects that have had stops and starts. We've never seen a sustained effort to collect data, you know, and then even things like the early warning system that I talked about earlier, where that's been demonstrated to have success in other jurisdictions. So, you know, what we're doing, and what I know other organizations are doing, is that they're continuing to push, you know, police services across the province to look at those measures, right? Because there's a lot of work to do. There's a lot of gaps right now, you know, both at the sort of police services level, you know, the local level, and at the provincial level. And I think that there's so much more work for us to do. And hopefully through a process where we can engage with the police services, work with communities, to land on the right response. But I do feel like it's definitely a moment to seize. And I think, you know, as all of the co-panelists have said, like, it's just something that we have to continue to push.
All right, thank you for that response. I'm going to take one more question, and we're going to go to the outro. But Ayana, are you there?
Yes, I'm here.
Okay. I think you asked a question too. I think you just answered your last question about the data collection, and you had another question?
I think that was the one.
That was one. Okay, so I'm going to take one last question then. It's going to be for Joe. Joseph.
Yes, please.
There you go.
So one of the things that I've always thought about, even this whole situation, I have much talk about systematic racism and policies and all that. But always know that children always learn certain behaviors and perspectives from home. And also the more time they spend at school, because most times they leave home, they go to school to socialize and end up learning new behaviors and all that. So one other thing I think that should be done, one, they should also think of whatever discussions we're having right now, how can we make it age appropriate? There are certain words, of course, we may not be able to use for the young ones to understand, but we can organize this data, we can organize this presentation, and it goes through reviewing by the Minister of Education and all that. So it can also be taught in schools, so that people are aware of the meaning of the different races in the country. There are kids who have gone to only white schools who don't even understand, and they will keep on asking whenever they see other kids from other schools with black hair or black kids, they'll begin having that discrimination, and they don't understand why is our skin different. We are all humans, we have the same anatomy, just the skin color that is different. And now, so as much as we're doing that, I think one of the way forward is to push and advocate to have that some of these topics can be integrated in the school curriculum, but also parents and guardians to become key in helping children and other community members to understand the existence of the different races, because we are going, all these races are going to coexist. They're not going to kill one race and leave one. That will never happen. It's going to remain. We need to find a way of living harmoniously, understanding each other. Let us not be the fear to understand someone's culture be a reason for you to discriminate them or to be racist towards them. So with that, if at all that is kind of considered and a roadmap is worked on, I think to also contribute a lot in solving this issue. Thank you very much.
Anyone want to take a shot at that?
I guess I would just acknowledge, you know, you know, all of those points, because I think they're all really important points. You know, one of the big issues that we've been looking at in connection with police services, several police services across the province, is the presence of school resource officers. in schools. And as some of you know, that's been a, somewhat long-standing program, at least in some jurisdictions, that was initially born out of this idea that you would have these police officers in schools and that they would play this liaison role. And it would be kind of this role where they would, present sort of a, kind of the kinder, gentler face of the police to kids and educate them on the role of policing. We know that in a number of communities, it hasn't played out that way. It hasn't played out that way in the deployment of officers to schools. It hasn't played out that way in terms of which officers are assigned to those schools. It hasn't played out in the sense that what we've seen in some very egregious examples is the lines have become blurred, where this function of being a liaison officer has turned into kind of more enforcement function. And that, it's actually traumatized students, students of color, Black, Indigenous, and other racialized students. And so, there's been, a lot of concerns raised about that. And I know that in certain jurisdictions, like in Toronto and Hamilton, they've actually eliminated the school resource officer, and they've actually saved a lot of money in their policing budget as a result of that, which hopefully they are now going to be looking at as part of, these discussions we're having around defunding, to reallocate to other, services that address the needs of communities. But I think, in the aftermath of eliminating that kind of existing program in the way that it has existed, we do need to think about the points you're raising, right? About, what information are we sharing with our students, right? And, what image of the police are they seeing? Are they seeing, pardon the expression, but a whitewashed, image of policing, or are they going to hear a more complete version of what policing looks like and what experience, many communities have experienced? So I think that, the points you've raised are really, really important ones for us to consider as we're working through, how to reform current policing.
Thank you, Raj. I'm going to turn over to Ines just for the wrap up.
Thank you. Okay, first I want to say thank you to all our special panelists for all this information, and it's so good to learn all this information and sink in our brains. I want to thank to all everyone else that joined us on Zoom for their time. I would like to ask everyone to join if they have any workshop they like to see in the future, if they could send email to Mark. And there will be more in the future, more workshops that we have set up. So please join us in the next Zoom. And I just want to say thank you again to everyone for joining us.